You have a concealed carry permit. You passed the background check. You completed the training. You did everything by the book. And then someone tells you, you cannot bring your firearm into a restaurant, a shopping mall, or a grocery store, unless the owner puts up a sign giving you permission. Does that sound right to you? The Supreme Court of the United States just answered that question. And the answer is going to change how millions of Americans carry their firearms every single day. Stay with me, because by the end of this, you will know exactly what changed, what it means for you personally, and what mistakes you absolutely cannot afford to make. Welcome to Law Unlocked, where we break down real American law exactly the way your lawyer would explain it to you. Plain English, no confusion. Just facts you can use. On June 25, 2026, the Supreme Court handed down two landmark gun rulings in a single day. Both expand your Second Amendment rights significantly, and most Americans have no idea what these rulings actually mean for them. Let's break it down, right now. Let me start by explaining what was actually being decided, because this is where most people get confused. The Second Amendment gives you the right to keep and bear arms. That is settled law. But states have been fighting back, trying to limit where and how you can carry, even if you have a valid permit. Hawaii was the perfect example. After the Supreme Court expanded gun rights in 2022 in a case called Bruen, Hawaii passed a new law. This law said, even if you have a concealed carry permit, you cannot bring your firearm onto any private property open to the public unless the property owner explicitly gives you written permission. Think about what that means in practice. Hawaii's law imposed severe restrictions on the daily activities of residents who had already satisfied the state's rigorous requirements for a carry permit. Outlier kit restaurants, parking lots, shopping centers, gas stations, all private property open to the public, all off limits under Hawaii's rule, unless you had a signed permission slip. The Supreme Court just said, that is unconstitutional. On June 25, 2026, the Supreme Court ruled 6-3 in the case of Wolford versus Lopez. The court held that Hawaii's law prohibiting licensed concealed carry permit holders from carrying handguns on private property open to the public, without the property owner's express authorization, violates the Second and 14th Amendments. Outlier kit. In plain English, if you have a valid concealed carry permit, the default rule is now that you can carry in most places open to the public. The owner must actively post a no-gun sign or tell you to leave. The burden is on them, not on you to get permission first. But that is not all. The same day, the Supreme Court also ruled unanimously in a second gun case. The court struck down the federal law that banned marijuana users from owning firearms, ruling that enforcing that ban against people who use marijuana in states where it is legal was unconstitutional under the Second Amendment. Flux note, two rulings, one day, both expanding your gun rights significantly. Now, the part that matters most. What does this actually mean for you as a gun owner? If you have a concealed carry permit, you no longer need the property owner's permission to carry at most businesses and public spaces. If a business wants to prohibit firearms, they must clearly post a sign or verbally inform you. If there is no sign, your permit covers you. If you use marijuana in a legal state and own a gun, the Supreme Court changed a federal rule, but your state is the layer that actually governs your permit. The federal ruling is one layer, state law is another. Fleeky. What this means, the federal charge for possessing a gun while being a marijuana user in a state where marijuana is legal is now unconstitutional. But your state permit office may still have its own rules. Do not assume you are automatically clear. If you live outside Hawaii, before you act on anything, read your state law. The Supreme Court shifted one federal piece. The rest of the machine is still running on state law, state permit offices, and state definitions the court did not touch. Fleeky. Now let me tell you where people go wrong, because this is where I earn my keep as your attorney. Mistake number 1, assuming this applies everywhere immediately. This ruling came down June 25, 2026. States are still responding. Some will comply immediately. Others will pass new laws to work around the ruling. Check your specific state's current law before you change your behavior. Mistake number 2, ignoring posted signs. The ruling does not give you the right to carry everywhere with no exceptions. Sensitive places, schools, government buildings, courthouses, hospitals remain off limits. And if a business posts a clear no firearms sign, you must comply. Ignoring a posted sign can still result in criminal trespass charges. Mistake number 3, marijuana users thinking they are fully clear. Even where state and federal law both now permit a marijuana-using gun owner to possess a firearm, marijuana use creates prosecutorial risk after a defensive gun use. A prosecutor can raise marijuana use as evidence of impaired judgment. Being legally permitted to own a firearm and being legally defensible after using it in self-defense are two completely separate legal questions. Fleeky mistake number 4, carrying across state lines without checking. A permit valid under your home state's interpretation may still create issues in a neighboring state with different laws. Check reciprocity before you cross a state line. Fleeky. Here is exactly what I tell every client right now. Do these things in this order. Step 1. Check your state's current concealed carry laws. Go to your state attorney general's website. Laws are updating right now in response to this ruling. Step 2. If you carry at businesses regularly, know what a valid no firearms notice looks like in your state. The requirements differ. Some states require specific sign sizes, specific language, specific placement. Step 3. If you use marijuana in a legal state and own a firearm, consult a licensed attorney in your state before making any decisions. Do not rely on what you read on social media. Step 4. Never carry into a sensitive place. Schools, government buildings, polling places, courthouses, these remain restricted regardless of this ruling. Step 5. If you do not have a concealed carry permit yet, now is the time to get one. The process varies by state, but generally includes a background check, safety training, and an application fee. The Supreme Court just handed gun owners 2 major victories in a single day. Your Second Amendment rights are stronger today than they were last week. But stronger rights come with stronger responsibilities. Know the law in your state. Carry responsibly. And when in doubt, consult a licensed attorney before you act. If this video helped you, share it with a fellow gun owner who needs to know this. Subscribe to Law Unlocked. Every week we break down real American law in plain English, exactly the way your lawyer would explain it to you. Drop your questions in the comments below. I read every single one. This video is for general educational purposes only. Laws vary by state. Please consult a licensed attorney for guidance specific to your situation. See you in the next one.